My lords, there is an intervention
The other thing,
application.
I'm telling you another thing, and that Mr. Solicitor, Mr. Dwivedi, forget this issue, and your arguments. If constitution benches really have to go on, with 5 judges leaving their regular work, that's why Chief Justices before me have not constituted constitution benches, because you don't know the kind of pressure. Every evening I ask, what is the filing? How much is the disposal? We don't want to add to that's the real problem in our court.
Yes.
The inflow is so heavy. Unless we start rationing time, it's impossible to list constitution benches.
Then your lordship may say that after Dr. Singh leaves, everybody is rationed out. We don't mind.
My lords,
15, whatever your lordship wants. In the interest
See,
of time.
may I just say one?
Yes.
All this oral hearing which is happening is meant to give some voice to the people.
Correct.
But our real work begins after, right? So don't be under the impression that if you don't get to address to your heart's content, we will not apply our mind. Our duty lies elsewhere. That once this is over, the whole court system is right now geared as though everything depends on what you say or what you don't say, which is not correct. Therefore, please keep that in mind, restrain yourself to the extent possible and present the clearest picture without taking us through too many things. If you start referring, then we will be shuffling pages. Our focus will be there. You want to argue, you look at us, make your point. Somebody said US Supreme Court, do that. Then don't refer to anything, just refer to the pages.
we will do that, my lords, and subject to my lords' preference, perhaps we could take that note, cut it down pro rata, and we will finish by Monday for sure.
All right, now what we'll do is, we have now indicated, we will start hearing Dr. Singhvi. Dr. Singhvi, wrap up by 12.
Your lordships are really
please.
keeping it on Monday.
It starts at 11:40, provided it starts.
Provided
Lordship,
12:30 that. Now,
Yesterday, I'll be racing.
yeah, we gave you a compliment of the expertise too.
No, your lordship will see. I am not going to repeat a thing. I am only saying, please count my 45 minutes from when I start. That's all.
all right, Dr. Singhvi, we start now. Your time begins now.
only one clarity.
So turn to 140.
So what is your lordship's direction?
After this, yesterday we indicated we are going to hear Mr. Vishwanathan. Mr. Grover, you can argue after Mr. Vishwanathan. Mr. Raju Ramchandran after that for a bit. Then we'll hear. You've given us the order. That's great.
Yes.
No.
Your lordship,
Can I?
one.
All right. So after this, Mr. Ramchandran, then Mr. Vishwanathan, Geeta Luthra, Mr. Grover, Jaina Kothari, the order which you have given us in
There was an initial list, my lord, which was circulated by the nodal council in which my name was included. And that seems to be, my lord, omitted from the revised list. I've communicated with the nodal council. I'm only seeking, my lord, a 10-minute time. Not more than that.
Why are you appearing?
In support of the petitioners, my lord.
My lord,
In support of the petitioners in
What is
the
it?
main guy. For a gay activist, my lord, from Bombay.
50 gay activists, are we supposed to listen to every gay?
No, my lord, I'm only seeking a very short time merely because my
No,
lord,
but tell
the
us.
theoretical aspects, my lord, of anti-discrimination law.
We should-
In particular, my lord, the theory of disgust by Mata Nuzma, only to elaborate on that, I'm only seeking 10.
Anybody who's an activist should come and address this court.
No, my lord, only
Now,
only
That
because my lord,
can't work out like that.
Not like this.
How much time is your lordship saying?
Anyway, Dr. Singhvi will complete at 12:30 and Mr. Ramchandran thereafter by 1 o'clock. When we rise for lunch, we would have.
Basically.
Can we
Mr.
start now?
Grover, 1 second.
You will take it and.
Let's start now. By 1 o'clock,
Okay.
we would have completed with Dr. Singhvi and Mr. Ramchandran's argument.
Now your lordship's
I would
PDF.
request my lord only 10 minutes of time, my lord, because this court, my lord, is not
tell us
usually it does not
I'll
restrict
tell you one
arguments
thing.
of councils.
Look,
That's
we are
why.
also not ignorant. I've read Mata Nazbom extensively, and I still continue to read Mata. After my day's deed is done in the court, this is what we sit down and read to get some sanity in our mind also at the end of the day.
I'm
For
only,
Mata Nazbom, do you have to keep on interrupting by the minute over here? I'm appearing for a gay activist. I want to show you Mata Nazbom. Of course, just give us a note. We'll read it.
my lords,
That's a matter of joy for us to read. It's a matter of joy for us.
PDF 1180. PDF 1180 minutes.
I mean,
My
it's
lords-
difficult to tell you. I was factoring that, okay, now summer vacation is going to be on this judgment. We'll have enough time. There's not, the pressure of SLPs is not there. We'll sit down. So give us a note on Martha now.
The written submissions are already there, only to indicate, only to
Point
take your
it out,
lordship
just
through
point
that,
it out.
only I'm seeking some time, that is. After
My
the petitioners
lords-
conclude, my lord, there won't be any repetition on from my side.
Somebody will
My
then say, I
lords-
want to now point out Rosalind Dixon. Why just
My
Martha?
lords, I
Somebody
will
say,
seek
I want to
indulgence of
point
my
out
lords
Bruce
only for 2
Ackerman.
minutes, my lords.
All right,
PDF
we'll love to
11.
hear it. I mean, I have this all of it threatening to fall on my head in the night. I've got such a pile of unread books.
PDF page 1180. Let me rush
Yeah,
through.
chalo,
Would your lordships continue
PDF
on
page
Monday
1180.
also?
yeah, we'll start on Monday.
My lord's prerogative, my lord, Monday is a working day, my lord. My lord,
There's also working. No?
no, my lord, it's admission day, my lord. There are several matters, my lord, which are already.
All right, we'll see, solicitor.
But let this start, my lord. On our side, your lordships may give us.
Solicitor, have you ever seen us being unreasonable in the court? Then, just we have to put a little pressure on everybody so that
Your lordship would not curtail us, but I'm confident about it.
Your lordship has binary request. One request.
Otherwise, we are
one
answerable
request.
to our
one
own
call.
conscience, solicitor. We are
Your lordships
never will
would
until
be
we
guided.
feel that we have heard the matter fully. We'll,
Now, Malas, 1180 PDF. I'll just race through, Malas.
just 1 second.
What do you want us to open, Doctor?
1180, Malas, PDF, that compilation of last evening.
143 that we will.
I'm grateful. 142 is over, 143 and 144 gets Malas,
Volume.
Baroness Hale over.
Not precedent. Volume 4 foreign. मेरा तो volume 4 है. Foreign.
Yesterday evening, Baroness Hale, PDF 1180, para 143. Volume compilation 4.
Volume 4 foreign judgments.
Yes, it's actually open.
It follows.
Just a moment, please.
143 you were reading.
Correct.
That's where we stopped yesterday.
Correct, please. May I read?
Yes, please.
Yes.
It follows that a homosexual couple whose relationship is marriage-like in the same way that an unmarried heterosexual couples is marriage-like are indeed an analogous situation. Any difference in treatment is based upon their sexual orientation. It requires an objective justification if it is to comply with Article 14. Whatever the scope for a discretionary area of judgment in these cases may be. This is very beautiful, but it can be transplanted subject to my Lord discretion to the Indian Supreme Court, to our Article 14. Whatever the scope for a discretionary area of judgment in these cases may be, there has to be a legitimate aim before a difference in treatment can be justified. But what could be the legitimate aim of singling out heterosexual couples for more favorable treatment than homosexual couples? It cannot be the protection of the traditional family. The traditional family is not protected by granting people, which is denied to people who cannot or will not become a traditional family. What is really meant by the protection of the traditional family is the encouragement of people to form traditional families and the discouragement of people from forming others. There are many reasons why it might be legitimate to encourage people to marry and to discourage them from living together without marrying. These reasons might have justified the act in stopping short at marriage. Once it went beyond marriage to unmarried relationships, the aim would have been to encouraging one sort of unmarried relationship and discouraging another. The Act does distinguish between unmarried but marriage-like relationships and more transient liaisons. It is easy to see how that might pursue a legitimate aim, and easier still to see how it might justify singling out the survivor for preferential succession rights. But as Lord Justice Buxton said, it is difficult to see how heterosexuals will be encouraged to form and maintain such marriage-like relationships by the knowledge that the equivalent benefit is being denied to homosexuals. The distinction between heterosexual and homosexual couples might be aimed at discouraging homosexual relationships generally, but that cannot now be regarded as a legitimate aim. It is inconsistent with the right to respect for private life according to everyone, including homosexuals, by Article 8 since Dudgeon's case in 1981. If it is not legitimate to discourage homosexual relationships, it cannot be legitimate to discourage stable, committed, marriage-like homosexual relationships of the sort which qualify the survivor to succeed to the home. Society wants its intimate relationships, particularly but not only if there are children involved, to be stable, responsible, and secure. It is the transient, irresponsible, and insecure relationships which cause us so much concern. Last para to be read. I have used the term marriage-like to describe the sort of relationship which meets the statutory test of living together as husband and wife. As husband and wife. Once upon a time, it might have been difficult to apply those words to a same-sex relationship because both in law and in reality, the roles of the husband and wife were so different and those differences were defined by their genders. That is no longer the case. The law now differentiates between husband and wife in only a very few and unimportant respects. Husband and wives decide for themselves who will go out to work and who will do the homework and childcare. Mostly each does some of each. The roles are interchangeable. There is thus no difficulty in applying the term marriage-like to same-sex relationships. With the greatest respect,
Dr. Singhvi, this was a case where
Yes.
the Act squarely applied to unmarried relationships.
Yes.
And the principle was that if you're unmarried, if the Act applies to unmarried relationships between heterosexuals,
Yes.
there is no basis to exclude unmarried relationships among homosexuals.
It is the second last
Right.
formulation of
That's
the
what
Lordship
is really
sentence
said.
which I'm concerned about, that when you have a particular paradigm applying to a heterosexual group, your Lordship, Malas, absent something very special, will find it discriminatory not
That's
to apply
why
it
the
to
judge
another.
uses, Baroness Hale uses the expression marriage-like relationships.
Yes.
So these are not marital relationships, marriage-like relationships of heterosexual couples who are in a stable relationship, but who are not married. They said that therefore, if you are extending protection to heterosexual couples who are in a marriage-like relationship and therefore not married, there's no basis to deny it to homosexual couples who have a marriage-like relationship but who are not married.
I'm
That's the
grateful, Malas, that's one. But Malas, the language of the paras I've read yesterday and today
Maybe
are
also
very,
capable of
Malas,
extension, you're right.
appropriate. And your Lordship is not bound by these judgments. Your Lordship will find persuasive value to the extent your Lordship finds. Now I turn to that article, Malas, which according to me is one of the most well-written articles on interpretation. On reading down, reading up, what your Lordship
Well, which is that article now?
treaty compliant, or in our case, constitution compliant reading. Constitution compliant reading. Kindly hand over. It's better to use the hard copy. I'll read only 3 sections, a few pages of it. Kindly hand over.
Oh, okay. Sorry, I was just. Thanks.
We have also emailed you, but this is better and quicker. The Lordship may mark this.
The judgment is done.
That is done. That is over. Now, kindly come to the first page. What is the year of this? What is the year of this publication? Don't do multiple things. Focus. Year. Just come to the first para. Your Lordship will ignore. I mean, it's about UK and New Zealand. Second para on the first page. On the first, I'll be making Your Lordship mark only some portions. It's rather well put, Wallace, and it is triggered by, that's the reason I'm citing it. The key question for the courts in applying such directions is how to determine when it is or it is not possible to ascribe a rights-consistent meaning to the legislation. Although a definitive answer to that question has proved unsurprisingly elusive, a shared assumption to date has been that the line that is being drawn, this is the point for this, line that is being drawn between interpretation on the one hand and legislation on the other. The task assumed by the courts is to search for an interpretation of the relevant statutory provision that would bring it into conformity with human rights standards. Now come to page 2, Malas. Beyond the margins of interpretation, however, lies the constitutionally impermissible territory of judicial legislation. And that's your Lordship's Malas equation. The next parameter, given this characterization as essentially interpretive, it is perhaps unsurprising that I'll skip the New Zealand specific para, come to the third para. In the United Kingdom, however, and this is important, a new model now seems to be emerging. In a series of cases, culminating in the decision of the House of Lords in Ghedan, I just read it, the United Kingdom courts have cast doubt over the centrality of statutory language to the determination of whether a rights-compatible reading of legislation is possible in the right of the Human Rights Treaty. The text is not, the law lords have said, determinative. The text is not determinative. Rather, the courts will be constrained only, mark the word only by the underlying thrust of the legislation A and the limits of their institutional capacity. Now, Malas, the counter question, the devil's question, is posed in the next paragraph. This paper discusses Ghedan and its implication. It suggests that the remarkable aspect of Ghedan is that it simultaneously divorces the process of statutory interpretation under HRA from the twin anchors of parliamentary intention and statutory text. This I'm relying upon heavily, Malas, this first sentence. The second part, in that light, it is suggested that the dichotomy between interpretation and judicial legislation is at the very least under pressure, and the courts are in fact appropriating to themselves a significant, if nevertheless a subsidiary slice of legislative power. Now come to Malas page 8. Page 8. So, ready to write it down. Page 8. Of the 4 law lords in the majority,
Yes.
of the 4, page 8, Malas, 8. Roman, big Roman 2. Of the 4 law lords in the majority, the names are given. All but the last delivered a separate opinion on the correct methodology under 3.1. There was, however, substantial agreement on these essential principles. Then the key issue, separating the sheep from the goats. Their lordships identified the key issue under 3.1 as being how to determine the limits of what is possible. The scheme of 3 and 4 of the treaty envisages that there is a Rubicon which the courts may not cross. What is not, however, spelled out is the test to be applied in separating the sheep from the goats. Parliamentary intention is not the touchstone. This is another red herring which your Lordship may have to deal with in the present case. In investigating the line between the possible and the impossible, Lord Nicholas and Lord Stein held that the courts were not constrained by the intention of the Parliament that enacted the legislation. Very, very important. Lord Nichols distinguished the required approach in this respect with the orthodox approach to standard statutory interpretation, which involves seeking the intention reasonably to be attributed to Parliament in using the language in question. In contrast, Section 3 may require a departure from that parliamentary intention. Departure from that parliamentary intention. The key question being how far and in what circumstances. This is because there is another and countervailing parliamentary intention which needs to be given full weight. Namely, Malas, the intention reasonably to be attributed to Parliament in enacting 3. So it's an objective test being brought in. Objective. Now, nor is the statute. The second thing which is not determinative is statutory text. And Malas, it is quite interesting and astonishing, though now in a constitutional context, American English courts are saying this. When we were brought up, Malas, it would be sacrilege to suggest this to an English court. Remarkably, their lordships held that the language of the statutory provision at issue is not the touchstone in deciding which it is not possible under 3.1. This holding had a number of dimensions. Further, their lordships expressed concern about excessive concentration in a literal or technical way on the linguistic features of the statute. Rather, Section 3 requires a broad approach, concentrating amongst other things in a purposive way on the importance of the fundamental right involved. So intention one way, statutory text one way. Now we've got a third test, importance of fundamental right involved. Secondly, their lordships stressed that the proposition that ambiguity in the statutory language is not a prerequisite to the operation of 3.1. Ambiguity is not your lordship's poll star. Thirdly, 3.1 might thus have a role even if the statutory language is not capable of bearing 2 meanings. Lord Nichols says, once it is accepted that 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose that Parliament intended that the operation of 3 should depend critically upon the particular form of words adopted by the parliamentary draftsman in the statutory provision under consideration. That would make the application of 3 something of a semantic lottery. From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with a convention-compliant meaning does not of itself make a convention-compliant interpretation under 3 possible. So this is impossible, impossible. So your lordship's ultimate guide star is intention, no. Text, no. Parliamentary, well, is overall purposive theological, no. But the ability to achieve a convention-compliant result. a convention compliant result. Next page, Wallace, at page 10, I'll just read the quotation. Fourthly, their lordships considered that 3.1 empowers the court, if necessary, to change the meaning of the legislation. This is actually the heart, the legal heart of this case is this, Wallace, interpretation, how to look at these sections. 3 enables language to be interpreted restrictively or expansively, but a 3 goes further than this. It is also apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. It is apt to require the courts to read in words which change the meaning of this enacted legislation so as to make it convention compliant. In other words, the intention of Parliament in enacting 3 was that to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of both primary and secondary legislation. Their lordship's view is not the touchstone in determining whether a convention compliant reading of legislation is possible, begs the question. If not the words, then what? How then is one to sort the sheep from the goats? Their lordships identified 2 overlapping limits. So now he's answering the question, how do you separate the sheep and the goats? What is possible under 3.1? This is the first test, fellows. General thrust of the legislation. Second is court's institutional capacity, which is defined later on, coming out later. As to the first, their lordships held, 3.1 does not authorize the courts to adopt a meaning that is inconsistent with what they variously described as fundamental feature of legislation, underlying thrust of legislation, grain of legislation. Each of the footnotes gives a lordship the para. A cardinal principle of legislation, the very core and essence, the pith and substance of measure. Well, to take a 5-second aside, it is a kind of a basic features intra-legislation. Basic structure doctrine, intra-legislation. Right. These are well as interesting developments. The lordship is... The
tenor and the provision
tenor
of the law.
Exactly.
That internal, does it make
Intra, it has to be intra.
You can't confine it to...
Correct.
Wow.
This notion that the courts cannot turn, page 11, 11 top. This notion that the courts cannot turn the scheme of the legislation inside out overlaps with the second point, which is that the courts cannot make decisions for which they are not institutionally equipped. Now, what is the meaning of this? Some cases that lordships held call out for legislative deliberation. So, if it's a case where a lordship finds the whole script has to be written, it has to go to the legislature. This might be the case, for example, if the exercise of making the legislation convention compliant would involve the substitution of a detailed statutory scheme. It's a very fair test, fellows, very fair test. Or if a policy choice needs to be made between different methods for achieving convention compliance, or if the decision would have far-reaching practical repercussions, the courts are not well equipped to evaluate. This has to go case by case, fellows, to your lordship's ultimate decision. Now come to 13, page 13, 1.3. In Ghaidan, however, lower part, second half of the page. In Ghaidan, however, the House of Lords rejects both a focus on text and a focus on purpose. I'm sorry, Justice Kohli doesn't have page 13, lower part. I'm just doing a little bit of speed reading, Your Lordship's permission. Now, Your Lordship, teleological purpose, Bennion. So even that is out. Both a focus on text and a focus on purpose. This creates something of a puzzle as to what their lordships might mean when they say that the interpretive possibilities created by 3 are limited by the underlying thrust, 1, of the legislation. Considered in isolation, that proposition might sound a restatement of the modern purposive approach to statutory interpretation. The purposive approach has, however, been explicitly rejected by their lordships. The intention of Parliament in enacting the legislation must, they said, give way to the intention of Parliament in enacting. That the underlying thrust approach is not consonant with the purposive approach is manifestly evident from their lordships' analysis of the statutory scheme, page 14, top, at issue in Ghaidan itself. Lord Nichols postulated that the social policy underlying the extension of security of tenure in 1988 to survivors of de facto opposite-sex relationships was equally applicable to survivors of de facto same-sex relationships. On the basis of that essentially normative conclusion, he held that the underlying thrust, this is the test for us, the underlying thrust of the Rent Act of 77 did not preclude a convention compliant interpretation.
So then
The underlying
two parts. One is yes, this is how you make it consistent with the convention. The second is they abandon the purposive construction method.
and the textual and the intention based. Now, if your lordships were to find
Was it? Diametrically.
well, if
Steps
there's a
your-
prohibition,
I'm just
I would
asking
say,
again,
I would
yeah.
say, in fairness, the answer would be no.
Then,
If the language is diametrically opposite.
interpret it to
No,
choices
the
of the
lordship
court.
is, when your lordship puts that question, I am answering it saying that diametrically opposite must mean prohibition.
The prohibition, that could be.
Prohibition.
We are looking.
Answer has to be no.
let us- let
I'm
us-
not here, Bolos, to suggest your lordship that your lordship has a prohibition and your lordship is then overriding it on the basis of interpretation. Then your lordship may be able to override it for Bolos some second argument. It's not the only answer. Second answer is
But if
your
that
lordship
provision,
as not constitutionally compliant.
then when-
There are two ways of looking at this. One is that we challenge it on the ground of unconstitutionality, as we are doing the notice and objection provision to which I have just returned. Your lordship will then apply that test. The first test my Lord Justice Narasimha is asking me is intra-legislation. To that, the answer would be if there is a prohibition, and I still ask you to only interpret. Your lordship may have
How can
difficulty.
we confine to that concept, that if there is a prohibition, then only we say that it should go back to the legislative drawing board? Because,
No, if it's not constitutionally compliant on the larger challenge, no, your lordship can strike it down.
because, let me complete. We are focusing our gaze on the only provision. In Gaidan, it was possible. Gaidan, the question was simple. And also Gaidan was not essentially concerned with matrimony. Essentially, it was concerned with protecting tenants and whatever was the consequence if one of them who was living in a relationship died. So therefore, it was possible to not even go into the internal mechanics of the concerned enactment. Here, perforce, whether you like it or not, we will have to insert ourselves into the mechanics of.
Therefore,
Yeah.
Malas, therefore, two things. Ghedan, the underlying, although the issue was Rent Act, the underlying thrust was found by all 5 judges to mean that you cannot discriminate between heterosexual couples
Given.
versus homosexual couples in the interpretation of that act. Number 2, the question would be if your lordship found that SMA, the underlying thrust, is not this, or the SMA precludes that underlying thrust, then your lordship would go one way. If your lordship, however, to find that the underlying thrust of SMA does not exclude, and that's the heart of the answer to my lord's query, does not preclude or exclude a same-sex couple, that's therefore that choice ultimately follows the.
If presented the way Gaidan is presented, we have no difficulty. But if you take the steps in Gaidan, which is the internal sense of the enactment, then we will necessarily have to go into
The
other
two
provisions.
different acts, lordship naturally. This is Ghedan is something else, this is
Then
something else.
Then
I'm only on the
the
approach.
route
to
which
interpret-
we may have to take is something else.
Well, I'm only giving your lordships a approach to
Yes, you are
interpretation,
right.
which should comment your
It's
lordship,
quite a
obviously in a different context.
It's a
Obviously
very
in
novel approach.
novel approach and in
But
different
having
context.
said that, here you're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention,
Go beyond.
not based on original intention, not based on purposive teleological
So
interpretation.
you're really asking us to read into the statute the expression spouses for really man and woman.
So
And
does the
therefore-
underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct? Is the
Because
case?
your principal premise is that when the legislation was enacted in 1954,
Yes.
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage,
Absolutely, absolutely.
right? And not,
Special categories.
you are giving Parliament was intending to provide an avenue to people beyond
Beyond.
your religious, the religious governance of marriage, so to speak.
There was also an aspect of endogamy.
Yeah.
There was
Yes,
an aspect of endogamy
yes,
which
yes.
we cannot ignore.
Yes, yes, yes.
So
yes.
it was an all-enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special
after
category.
1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable
That's
relationship.
because you go back and
Therefore,
say, yeah.
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, if the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law,
Lordship.
then surely that law is capable of being broadly read according to you, so as to take into account more stable relationships
Let me put it
of
bluntly.
the same
Very
sex as
grateful.
well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
Way of
That
looking
makes
at
no
it.
difference.
You may
Another
not.
way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The
Exactly.
concept of marriage transcends
As it.
contemporary understanding to
It's an evolving,
comprehend-
dynamic concept.
to
Absolutely.
comprehend an evolving idea of
Dynamic,
marriage.
very dynamic concept.
So used in a constitutional sense, it only provides a framework.
Framework.
And that framework is broad enough to, assimilate later developments.
I
So it
don't want to.
transcends the existing.
I don't want to sound well. That is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone, or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new
or
statutory
would
scheme.
Yeah, exactly. Would the
New
court be
statutory scheme.
rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make?
Lordship.
So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test
equally,
was
I
enough.
think the impact of
Put a
Ghaidan
line.
is to liberate the court
Yes.
from the very, very traditional approach
Yes.
of looking at everything as a matter of statutory interpretation. Therefore, purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Malas. That teleological and purposive also, which is supposed to be in
play
advance,
again-
falls
play
back.
again- I'll play a little bit of a spoiler. Ghaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, Malas. Your lordship, that's the difference. It's a holistic thing your lordship keeps in mind. Ultimately, the feel of the case is only your lordship will. That is, nobody can be identical. Nobody is saying
Because
it.
I'm sure if you go to Ghaidan and if you follow it up, there could be other cases which have followed
Now,
that.
so I've now Malas, time, given my
Dr.
time.
Sigby,
I've done this.
Dr. Sigby, I think, I mean, looking at India constitutionally and socially as well,
Yes.
we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage-like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, but relationships in the relationship
On the
of
contrary,
marriage.
Malas, I started by saying it's a logical move in the same direction. It is, in fact, little done, vast undone. Your lordship is now getting to cover that territory, because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense,
Of
remain
course,
a
it
shell.
requires us to,
Hol-
of course,
hollow
it
shell.
requires us to redefine perhaps the evolving notion of marriage, because is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? Or has our law now progressed sufficiently to contemplate that the existence of binary genders may be, but is not necessary for your definition of marriage?
And Malas, to that comes in the intersection of the Article 14. You in your counter and everywhere else are underlining immeasurably the vital importance of marriage, to which I bow down.
Or
But
by-
that vital
or by
importance of marriage is
expanding that
restricted
defi-
to one category.
Expanding that definition, are we then trenching upon that area which Gaidan excludes to the judges?
That is, Malas, in case your lordship has got to stitch a whole cloth, which only a statute can do. That ultimately will be a lordship's Malas call. I don't think at all, which now Malas, Josh will just note on the side, para 44 has some other cases similar to Gaidan. I'll not read them. I don't have time to read them. Para 44 of my submissions. I'll now come to Malas that 3 or 4 queries arising under the SMA, and then come to the notice of objections regime.
But in a way, Dr. Singhvi, I think what happened in the UK is really, in that sense, not in that. I was just talking to Justice Call, is not really in that sense in all fours with what happened in India.
Not at all.
The HRA in the UK was intended to enforce treaty obligations under the ECHR.
Yes.
Right? For us, we've always had the overarching principles of the
Well, that's
Constitution,
the-
which lie above. In
That's
that
the irony. We are A for sure, Malas, with respect. I am saying on interpretation. This case is cited and the article is cited only for an approach to
And,
interpretation.
we are not
far
here,
ahead.
we are not here using the Constitution or utilizing the text of the Constitution to either read down a statute or to strike down a statute. That's one element of the impact of the Constitution. The other thing which we are doing now here is expanding the meaning of a statute in the context of constitutional guarantees. And in that, you are saying be liberated from the bare text of the Constitution or the notion of
That's the
parliament.
first part of what I argued yesterday was dignity, non-discrimination.
See, in the backdrop of constitutional interpretation, we have never used the originalist doctrine, right? India, unlike say what Justice Kalia said, we have never regarded ourselves as bound by an originalist interpretation
Kalia
of
is
the
an extreme
Constitution.
example.
In which case, Dr. Singhvi, if we have
extreme
never been bound by an originalist interpretation of the Constitution, should we be bound by an originalist interpretation of the statute, which is in that sense subordinate to a Constitution?
And he, Their Lordship knows that a court of one. He said, if I'm the only one, I'll always stick to this original intent. Court of one. So, your basic, so all that I'm saying is, one, because I've done the constitutional aspect, yes, unless Your Lordship anchors it in the values of 14, 15, 16, 19, 21, that's the
But
first
to
part.
put it really bluntly, is the relationship between a man and a woman
Yes,
so fundamental
yes,
to our law and therefore the Special Marriage Act
yes.
that for us to comprehend that it will also include a relationship between a same-sex couple would be completely redoing the tapestry of the legislation?
So this
If
is,
we say yes, then obviously we cannot
the
accept your
underlying
position.
agnostic thrust is the underlying agnostic thrust of SMA, antithetical to your lordships recognizing what Article 14 normally will always include, namely same-sex persons enjoying the same importance and benefits of marriage as different sex persons. That's the long and short of it. As an aid to interpretation, I've only cited one case which says, and the only interpreted statutory out of the Constitution. Does the underlying thrust, alternatively, an interpretation of SMA, prohibit or preclude your lordship from doing so? Or is your lordship's institutional capacity so compromised by a particular case that your lordships cannot do it? That's the fourfold way, connecting yesterday and today.
And really, your argument is that, the institution of marriage in itself
Yes.
is so very important that
to
deny it to same-sex couples would be really contrary to fundamental constitutional values.
Sorry to interrupt, my Lord the Chief Justice, because my note yesterday, I said it, para 15 lists 7 important indicia of marriage, and the appendix lists more. Their counter says so. I rely on it heavily. The question is only exclusion. You have it for that side of the table, you don't have it decided. Para 15 of my submissions. My lord were kind enough to note it down also by hand. Now, there, without that, if I was to straight away jump into an interpretation exercise of Ghaidan, it would be wrong on my part. I'm completing my argument.
All right,
I'm
Dr. Singhvi, we're just reminding you it's 12:17.
No,
Now, Ghaidan is over. This article
No,
is
therefore,
done. We've got the trust. Now, what's the next one?
the next one. Now, let's very quickly. One, I'll be very pointed. Justice Bhatt put a question to me about Justice Lahoti's order. That's 2005, 3 SCC 313.
That yesterday stage.
Don't bother, just I'm giving a copy to your lordships. Just note, it was a different case. Justice Bhatt said so yesterday. It's a different case. Context was different. It was really about, again, a tenancy law invoked by.
This was in the absence of the domestic.
Deserted wife to claim tenancy, etc. But leave that, Para 1, your lordship will note, the words are evocative. I'm just moving on. Just para 1 of that,
Dr. Singhvi, what exactly? 2005, 3 SCC?
2005, 3 FPC, 313. Just note para 1. I'll read it fast, lordship need not open it. I'll just read it for lordship. Only para 1. The law, it connects with what I'm saying, and therefore your lordship put this question to me yesterday. The law does not remain static. It does not operate in a vacuum. As social norms and values change, laws too have to be reinterpreted and recast. Law is really a dynamic instrument fashioned by society for the purpose of achieving harmonious adjustment, human relations by elimination of social tension and conflicts. I'll leave it at that, That's just a. The second thing, my Lord Justice Bhatt put to me. My Lord, remember that passage, so I've traced it out. That's only. Secondly, my Lords put to me. My Lords put to me.
The contractual relationship.
Yeah.
This is our Ghaidan moment in a different context. It's our Ghaidan.
This is a kind of a Ghaidan. I mean, it's a little, your Lordship is right. That's a tenancy case. But
You see, the interesting part is this predates the domestic violence in act.
Domestic. That's what your Lordship put to me yesterday. That's the point. That's the point. So they static, dynamic, moving. That's the whole point. Second, my Lord put a question which will have to await research. I can't give a Lordship a different, but one of the examples I found. For example, in one narrow case of standard personal accident insurance, what my Lord put to me, is there a statutory regulation? There is by IRDAI, not in the mass of others, but in that, which use the phrase legally wedded spouse. Now, I will make that chart and give it later. I'm not considering, suppose your Lordship were to hold that SMA includes this form of marriage. They would be legally wedded spouse in the sense that your Lordship, after your Lordship's date of may fall within that again. But that is one of the few regulations which has the phrase. The large bulk doesn't. Where that phrase is there, it will depend, on your Lordship's judgment. But your Lordship's judgment, according to me, even where it finds same-sex persons in marriage valid, would be covered under that. I've given you a specific quote of a particular IRDA regulation. The third thing, is how to apply this gender. The third thing is, just note in bullets, the answer on this. This is important. Your Lordship has one situation about 2B and the first schedule of the Act. Answer, both parts of both schedules will have to apply to non-heterosexual couples. The prohibited category yesterday Lordship discussed.
Yes.
Two parts both parts of both schedules will have to apply to non-heterosexual. It does no violence to your lordship's sense of malice that your lordship is making a statutory scheme. Nothing. The statutory scheme exists. My lord is not saying whether he and I are prohibited category. Whether he and I are prohibited. Lordship is not defining. Your lordship is saying it will apply on both parts. That's answer number one. No,
Can you
no
say that
violence to
again?
the underlying
Can you
trust.
say that again? Can you say that? Repeat that.
Yes, the two schedules in question for the issue of prohibited degrees of relationship will apply, both of them simultaneously, to all non-heterosexual couples.
That's what Mr. Rohtgi said.
That's right. So we are now ironing out your lordship.
Collapse into one.
Yeah. Suppose your lordship has to make out a prohibited relationship. That would be legislation. Suppose your lordship, I am asking to do something which creates something. Nothing. Your lordship is reading in something and making it harmonious. Second, 4C, age 4 items. One I've done with prohibited degrees. Second is age. There are the 4 questions here, Rosemalas. Age, the simple and the correct solution is, Malas, that whichever of the same-sex couple is involved, that age will apply.
Sorry?
First is prohibited degree. I've
That's
both. Second is, Malas, age. Whichever of the same-sex couple is involved, whether it is 2 ladies or 2 men, that age will apply, be it 18 or 21. I'll come to the gradations in a minute. Give me a minute. Without having any stitching to be done on a legislative cloth. Third, now the question may arise, what about trans categories? The trans categories, your Lordship will hear other people are there. My own humble submission would be, in 99% trans categories, your Lordship is able to slot the person as per the gender which he or she professes, says belongs to, claims, etc. Because a trans means a man's body but inclined to be a woman, or vice versa. So if your Lordship were to then follow that slotting, and if the person is a man, otherwise biologically in say leaning towards the feminine side, then the age of the feminine will apply, or the age of the male will apply, vice versa. The fourth point here is, the fourth point is that your Lordships will keep in mind that I am focusing on what is all these petitioners, they are focusing on the discriminatory parts of the provisions. We are not challenging every provision or interpreting every provision. We are challenging the discriminatory portions of the gendered provisions. Gender provisions which are, so we are not concerned with every provision. And certainly the government of India is not challenging any provision. So your Lordship will see only our challenges or our reconciliations where necessary. Fifthly, some provisions which may not create any confusion, like 27(1)(a) of the SMA, only an example. They are peculiarly, conceptually, designedly created and applicable only to heterosexual relationship. Rape. I mean, you cannot have a system which applies uniformly to every category.
No, why?
Rape.
Why can't it apply to a homosexual couple?
No, with a caveat. Well, it's a criminal offence which has been defined. I will find the shortest definition is non-consensual penile vaginal penetration. It's one simple way of putting it. Now, of course, it has been expanded after the Verma committee to mean other forms of but otherwise non-consensual penile vaginal interface. Penetrative. Now, it is true that as well as rape, apparently rape is a crime even by a woman or a man in France, as far as I know. Those are special cases. Today, your Lordship's issue is, can your Lordship not move forward by these kind of possible obstructions?
Then we admit that in this case it will apply to one kind of one kind of same-sex partner. This marriage offense,
yes,
the marriage offense, will apply to one kind of same-sex partner.
It is possible. I'm only saying it differently because it's a crime. According to me, it will be covered in a penetrative same-sex situation also.
No.
But it's a crime. A crime would have to be
we are talking of outside of the marriage relationship. When you indulge in that, that's a matrimonial offense, entitling the other spouse.
No, it will be only if your Lordship holds this marriage. Your Lordship will have to hold this category of unions to be a marriage first.
That's right.
Then the question will arise. Yes.
We're testing that if
yes, correct.
Then it will apply to one class of same-sex.
No, therefore, there are two ways. I mean, I can see there are two ways. One is that if your Lordship holds this class to be covered, then your Lordship would have 27 applying to penetrative assaults.
Then we have in this.
No, even for the same sex. Even with the same sex. That's the logical conclusion. Alternatively, your Lordships could draw a line saying it's a criminal offense which has been defined in a heterosexual context. These are the two options. I can't say more.
Then we have three categories, really speaking. We accept the first option which you are offering, which is that A, it applies to the male.
If it otherwise satisfies the definition.
Third, it will not apply. So there are three meanings to the same enactment.
Is from moving ahead.
No, it applies
These are
to the extent it applies.
There are some peculiarities.
In a heterosexual relationship,
Yes.
uh, say there can be possibility of reading a rape into it, then how can in a homosexual relationship it not be read?
Not be read.
Well, I'm saying in fairness, I started by saying that. Well, in logic, no. In logic, no.
Can your lordship
There's a conundrum.
use the mic, please?
I thought I said in a heterosexual relationship, if in case of a married
Logically,
couple,
no. Correct.
there can be rape, then how is it possible that we don't have a scenario where in a homosexual relationship the same principle will apply? The same principle.
So, Malas, if your lordships were to, Malas, apply the definition of non-consensual penetrative sex, Malas, then it would apply. Logically, that's the correct answer. With great respect.
That's the little trouble of seeing how we get into different sections, how we get into different laws,
Right.
how we get into it. So the debate would be whether we stop just short of saying, you are saying it may be empty shell, but should we stop short? I'm just thinking
No,
about
no, Malas,
of
may
just
I
saying-
answer it? May I answer it?
just saying that this is under this act, such a marriage is possible and registered. Thereafter, there may be many, many nuances which will arise.
No, there's
Can we take care of all future eventualities?
no, Malas, there is one flip side to it. There is one flip side to it. Malas, there's a flip side to it. I'm sorry, I'm not completed yet. Malas, this is important. I'm not completed. Malas, marital rape is not recognized yet in this country.
That's right.
Marital rape, that's the fourth one.
That's an issue. pending.
That's the issue pending. Today, the law is not marital rape, Malas.
No.
Therefore, once your lordships were to read marriage,
There are people who are wanting us to move in that direction also.
that's
There are
Wanting us
matters
to move in a
pending.
different direction.
that's a different, Malas.
Not
No,
matters
no,
pending.
that's a different debate.
Marital rape too.
Today, as of today, rape, there is, Malas, it's not a recognized crime within marriage. It's maybe a ground for divorce or some cruelty. Cruelty is a better way of putting it. But now my point is different. My point is different, Malas.
The High Court judgment-
Karnataka High Court
Karnataka
judgment. that comes
That's an outlier in the sense that your lordship is still debated. It's not a law of the land.
This court has not taken a view on
You
it.
view it
There
is.
is the-
There's
But I'm on a different point.
a view.
If your lordships, this bench were to recognize the issue we are canvassing, within the marriage which your lordship recognizes between same-sex persons under SMA, your lordship would be recognizing, Malas, marriage within this act.
All I said was that whatever flows from a relationship, a law which will evolve on a heterosexual relationship would equally apply to a homosexual relationship. That's the point I was trying to make.
Very well. I leave it at that.
Dr. Singhvi, the other would be, and we are open to it, we are only putting a question, would we like to go that step further to go into these nitty-gritties? Because there are several shades on the palette.
No, but this is important. The first four answer is yes, your lordships can easily iron out. Now, my point is, I am not raising them. These are, I am answering, put your lordship as an insuperable obstacle. To your lordships to proceed. There are, well, these things will happen. These will be ironed out in the goodness and fullness of time.
Noted your argument.
That's all I'm saying. I'm not raising it,
There
Malas.
is a flag
I'm in
that
repulsion
there
on this.
is,
It can't
Stopping
happen
short of
in a-
many things is just an empty shell.
Right.
If we agree with you.
If we start.
Now, Malas, a few words and I'm done on notice and objections. The very important part. This is very interesting, Malas. Notice and objections. We are one of the few petitions where we have challenged it.
Will be in the
Go back to your written compiler.
objections regime. Very interesting, Malas, and very pointed. Malas, I will not read sections 5 to 9 and thereby save time. Your Lordship knows 5 to 9 well, Malas. Just note one thing.
Which para are you reading?
Malas, it is dealt with in para 47 onwards of my note, which is page 442 of your Lordship's PDF. Now, let me oralize in point formulas. First, your Lordship has got, Malas, Parsi marriages, Christian marriages, so many other different kinds of marriages. No other requires a notice of prior intent to marry. I'm saying something very different. Allow me to develop this point, Malas. This is, Malas, peculiar to the SMA, that before I intend to marry you, I must declare this intent publicly and wait. Number two, and there are all the other provisions, conspicuous place and all that, you should notice, and newspaper and all that stuff. Forget that, 5 to 9. Point number 2, at the constitutional level, Malas,
This is probably a throwback from the English era. Where you put out the bans.
Completely English.
To invite objections.
Well, it's reducing it almost to a sale of a house or a civil suit dispute. But anyway, that's a different issue. Let me say what I'm saying.
Look, this is a different issue. We have not filed a reply. This is tagged.
That's all right. It's
This
legal
is
issue.
entirely a different issue than the same-sex marriage. This applies to even heterosexuals, etc.
Yes, of course.
So that
It's
he
a
may
pure
not.
legal issue.
No, well,
It's a pure legal
please.
issue.
So that he may not address. Because there the arguments.
My
will be
learned friend
different.
has filed a reply. It is a constitutional issue. He has
No,
filed a reply. And it's can I just, in the middle of my argument, allow me to complete?
Yes, Dr. Singh.
Now, Malas, what's the constitutional issue I'm making? It's a very interesting one, Malas. This part is unconstitutional because before a formal entry into what I consider a vital form of society, marriage, you are invading my privacy by directing me that I must declare my intention in public domain for objections to be invited. Malas, which married couple, Malas, he and I are marrying in the heterosexual sense. When do we have to announce first to the world that we intend to marry and we are waiting for 1 month? In the heterosexual world. Forget heterosexual, Malas, in personal marriages, Malas, under Christian Act, under Parsi Act, under other acts. Why should I say, why should I? It's my personal decisional autonomy. It's my decisional autonomy. It's the heart of my privacy. It's the heart of my privacy to decide with whom I associate, when, how, after how much time, into matrimonial, Malas, union. Be it of the same sex or the heterosexual sex. Malas, it's taken, as my Lord put it, as
Post marriage, there can be a registration.
now, the next point. That's the next point.
Dr. Singhi, was this clause section there in 1872 Act, which is repealed now?
I'll just check it. I believe it was. I believe it was. 99% it was. It was. And Malas, I'm grateful because it's really a direct hangover from that Raj situation. But Malas, your Lordship are nowhere near privacy and all the 9-judge judgment and Puttu Swami and the dynamic. We have now a totally different world, Malas. Now,
It's based on patriarchy. It's based on patriarchy.
patriarchy. Now, that's now the third point. Your Lordship has in this act, as in other acts, a section 4, which says that you cannot marry if you are related, if your age is below 18. What are those conditions of marriage? My Lord has exact counterpart provisions in Christian Act and Malas Parsi Act. Conditions of marriage. My third point is, Malas, if you have conditions of marriage and you are requiring an affidavit to be filed that I satisfy all these conditions of marriage, the form is given. And if those conditions are found false, either spouse or even the outside world can challenge and get voidness or voidableness, as the case may be, then what is the purpose served with this prior objection, Malas? So now I'm on purpose, on just common sense. After 1 month, suppose I don't give a notice, I marry. After 1 month, Malas, everybody settle down. After 2 months, somebody said that these conditions are not satisfied.
No, who can? Who can approach the court then?
No, but Malas, even after, anybody can approach Malas.
Who has locus in a matrimonial?
Aggrieved
In a
spouse
matrimonial.
only.
Matrimonial, yes.
Only a spouse.
Only a
Not be a
spouse.
third
Spouse.
party.
Like bigger-
Correct, spouse.
Like a-
No, but I'm
only
saying,
a
Malas, if
wife.
there is a fraud, if there is a fraud of a gigantic nature, today, Malas, my lord is right. For variety of things, only the spouse can.
These are matrimonial,
Now-
aberrations or
Yeah,
offenses
yeah.
which only the spouse
No
is
question.
entitled.
Now, Malas, the point is, that's correct, Malas, that's correct. That's correct.
Absolutely.
That's correct. Now, my point is, I am at the moment, what are you serving by this 5 to 9? Now comes the fourth point. I'll tell Lordship what you are serving. In actual practice, in reality, even in heterosexual marriages. Now let us forget same-sex persons. That's the fourth aspect. I have shown that this should be unconstitutional. It serves no purpose. But what is the purpose it is serving for the last several decades? It is serving, Malas, the word your Lordship, one of your Lordship just now used, Malas, patriarchy. Patriarchy includes patriarchy also.
It was created at a time when women did not have agency.
Patriarchy includes matriarchy also, Malas. There are some agonizing
Women
cases.
never had agency. Women did not have agency when these laws and these.
Malas, this is an invitation to disaster and violence. It's an invitation, come.
And if the object was to protect
My spouse has no problem, but you
fall
please
back
come.
on their personal law,
Yes.
then by requiring, you're virtually laying them open to invasion by society, by
My spouse,
collectors and district magistrates and superintendents of police.
my spouse can challenge me anytime. But no, you please from the outside come here, your Khap Panchayat will come here, somebody will come in different form, where is gunning for you. That is not, what is the point of all this? Fellows in the High Courts, your Lordship have sat here and there, fellows, must have handled enough habeas corpus matters, fellows, coming to your Lordships. Why do they come?
No, I think in one of the cases, I remember having said that this cannot be given, it will destroy the entire purpose of marriage.
We have the case in our written submission, we'll point this.
Delhi,
Then, fellows, the other aspect it hits is choice. Individual decisional autonomy, privacy, individual dignity, this can all be put together, fellows. These are all constitutional core values.
Of course.
Interest. What is that supervening interest? I have not been able to find out till now. There is no supervening interest here. Some very great, unknown, mysterious interest. Now, let us to very quickly come. Some of it has been also read.
198 of the
The 47 to 56 of my note is what I've just finished oralizing. Now turn to 58.
Yeah.
2 minutes. Well, at one place it is there.
Yes.
I'm sorry, 56. 47 to 55, I have finished, Malas, just now. Come to 56.
Yes.
These cases, your Lordship may see at your leisure, Malas, are important. Just note the principle.
Yes.
Intimate decisions from non-consensual public scrutiny is para 56. I hope my lords have got it.
Yes.
And in particular, marriage is dealt with by Your Lordship Puttuswamy in that para given there. I've given all the paras 271, 297 specifically. Then, the right to privacy is not limited to private spaces but public spaces. It's been read, District Registrar need not be read. Navtej has been read fully, but just note the point. Then public-private divide is 58, fully covered already. That Mr. Rodgi did, leave it, leave it. There is an important phrase I've used, in 61, right to informational self-determination. That's Puttuswamy, para 248. Puttuswamy, para 248, right to informational self-determination. This notice and objection regime is directly the heart of it, And then, decisional autonomy is 65. That's the social context, including all the invitations to disaster. Well, 67 is an important legal principle of proportionality. Kindly give me 30 seconds on 67. This honorable court has recognized the possibility of a systematic abuse of rights infringing measures and read that into an assessment of such a measure's constitutionality under the doctrine of proportionality. This is excessive. This is completely disproportionate. What is the need for this in proportion, Your Lordships, said in Gujarat Majdoor, state action thus leaves sufficient room for abuse, thereby acting as a threat against free exercise of fundamental rights, ought to necessarily be factored in the delicate balancing act the judiciary directly applies. Your Lordship is inviting by this objections regime. And then, equality I've dealt with, in para 72. It's a discriminatory regime. Discriminatory because only if you choose the SMA, and if Your Lordship were to strike it down, please don't misunderstand, it's not to be struck down for same sex only, it's to be struck down per se, for heterosexual and non-heterosexual. It, is the only act. Personal law acts don't have it. This is a direct Article 14, And, I have given in para 80 a rather, pithy summary of proportionality. 5-pronged test, my Lord remembers. My Lord, I've called it out, 5-pronged test is a legitimate state object, a rational nexus between rights infringing measures, that is the suitability test, para 80. The rights measure should be least restrictive, that is the necessity test. Proportionality stricto sensu, that is balance between the extent and severity of the infringement and the object the state seeks to achieve, and sufficient safeguards against abuse. Well, it stops at B itself. If you add C, D, E, it is completely violative.
In my last week's judgment in Media One, I've sort of developed on the proportionality doctrine, which Justice Sikri evolved in modern day.
Modern proportionality.
And in Media One, we have tried to sort of further fine-tune it.
Least intrusive. Well, as I am done, I'm very grateful. One page at the end of some stirring words, which Your Lordship may or may not want to use. Just give it. Oh. This is really the heart of this matter. Ultimately, it's a larger matter than merely provisions. Is this correctly typed? Well, as I've given it in a bit of a hurry with some, I hope there are some typos. Just see these 4 quotations very quickly. One is this one. No, you don't know. Have you given it there?
Yeah.
Well, you Lordship will leave aside the top, what we are seeking. Just leave aside the top. Come to the quotations. Why do you add without asking me? Well, Oberfell and Hodges, it would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. These are the category like us who has said that why should you be entitled to marriage? Their hope is not to be condemned to live in loneliness, excluded from one of the civilization's oldest institutions. They ask for equal dignity in the eyes of law. The Constitution grants them that right. Whereas Oscar Wilde was a declared homosexual in an era when this was something very, very different. And he died, he was actually imprisoned for it. He fell seriously ill. And then he came out and he died. He put this, an alien tears will fill for him pity's long broken urn, for his mourners will be outcast men, and outcasts always mourn. He was talking in the context of men, Malas. And then, Malas, this is lastly, I have filed these cases. There is a case called Fitzpatrick.
Yes.
The House of Lords is, Malas, the final order. The dissent is what I've quoted in the Court of Appeal. This dissent was approved by the House of Lords in a reversal. I have come to a clear
Thank you,
conclusion.
Dr. Singhvi.
I'm very deeply
Thank you
obliged.
so much, Doctor.
I'm very deeply, deeply obliged.
In fact, filed a suit for defamation and lost on this ground.
Yes. Just 1 second. Sorry, I'm reading this one.
I'm very deeply obliged.
We begin with the hearing. We begin with Mr. Raju Ramchandran. And by the end of the day, we would have completed with the submissions of Mr. Raju Ramchandran, Mr. Vishwanathan, Ms. Luthra, and Mr. Anand Grover. We take it, 4 of you would complete by the end of the day. Thank you.